Tort. What is tort? Anybody?
We didn't complete that, the subcontractor and the client.
No, manufacturing. Manufacturing. That is
Become little stage.
which one? The one I told
Yeah.
it will come.
Okay.
That topic includes tort as well as privity of contract. That's why you have to this. Okay. Tort. Anybody? Okay. Tort is a wrong against society. I give you a hint.
Yeah.
Nuisance towards society. I told you in the starting with the word tort. Blocking the road, breaking the bridge. Not if it is criminal, it goes to criminal. Tort is civil. Compensation. Civil wrong. Wrong towards society. Originated from writ of trespass in UK's legislation. What is trespass? Yeah, question. This line is important.
Entering in
Entering into somebody else's property.
Only property.
Body comes under property.
No. Law defines both as different. If you know, tell us correctly. I know you know because I told you in some discussion, but you should. The definition says it's a body and property. Property, movable, immovable, there is a separate legal discussion. So the body or property, if you unauthorized entry you make, it is trespass. So from there, the law of tort comes. Law of torts is uncodified, means unliquidated, not like LD. It purely based on, there is no written law of tort. It's purely based on when something is not written and it's a law, from where it will come.
Consciousness. Consciousness.
It's a principle of what?
Morality.
Principle of what? Common law doctrine. Cases.
Common law.
Cases and maxims. If something is a law which is not written, from where it came?
Precedent.
Case law, precedences, and maxims. UK law is like the UK constitution is not written. It is taken from case laws, maxims, and that, and then theorems and whatever it is. So, law of tort is uncodified law. It's not written. There is no act of tort. Like this act number, this is no. It's purely based on case laws and doctrines, maxims. Nature of the remedy, compensation. There is no death penalty for any tort law cases. You will always get time or money. Okay. No fixed or written remedy like liquidated damages. It will typically depend on what laws you have made, what nuisance you have done, what negligence you have done, what defamation you have made to a person. He has to prove, court has to accept, and you have to pay. Common law principles, as Priyaranjan has clearly said, equity, justice, good faith, and inner conscience. Samant is a jurist. He says that a civil wrong, now taught what it is as per him, a civil wrong, it's not criminal wrong, first thing, for which remedy is common law action, means not codified law, it's a common law action for unliquidated damages, not fixed, which is not necessarily the breach of contract. It may or may not be the breach of contract. Your contract also has this clause, tort where, limitation of liability. That in tort cases, it is unlimited. Okay, because it's a public, you are doing something to the public. So you have to pay accordingly. Our 100% liability is not for the tort cases. So not exclusively the breach of contract or breach of trust or merely equitable obligations. Same way, now what is tortious liability? Tortious liability, as per Winfield, who is a jurist, he says tortious liability arises from the breach of duty primarily fixed by law. Where the law fixes a duty towards society and you do some nonsense, you will be booked under law of tort. This duty is towards the person generally. Generally means towards society, not one person. If these guys have dispute as per their contract, it has to be like decided as per contract law. But any two persons in the society, you are making a sound, you are burning your house, the next neighbor's house got burned. No contract was there, no contract, no, it's towards society. I can always claim it. Okay, that comes under this. Now, what is the difference, as I said, between contracts versus tort? Codified versus uncodified. Contract is codified because it is already documented as per the act. This is uncodified. There are case laws and maxims. You can ask for 1,000 years, you can ask for 9,000 years. The way you present well, the way you give your impact, the way the court will decide. Liquidated versus unliquidated remedy. For contract, it is fixed, it is written, while for tort, it is open, based on what impact you are making to the society. Liability as per contract versus liability in general. Contract, your liability is whatever written in the contract. But tort, you have unlimited liability. You cannot spoil or destroy the society. Privity of contract versus tortious liability. So now I am giving you two examples. You say whether what should be the solution. Two cases, and we are from UK jurisdiction. Winterbottom versus Wright. In this case, it was established that action in tort is independent of contract, which I say, and it is irrelevant and unjust to consider that privity of contract is essential for an action in tort. Means you work for him as per the contract, and I am a government officer. You break a bridge, and your argument is that I was working for his contract, bringing the material for his contract, which is 100 real contract. So I did that in execution of my work for that contract. Maximum penalty from me, you can take 100 real. Not possible, because it's a tortious liability. You did something wrong to the society. You are working for your contract, but your liability is held because public property you destroyed. So irrespective, irrelevant and unjust to consider that privity of contract. You can say you cannot sue me because as per the privity of contract, my agreement with him, and to whom I have not made any loss. I have made loss to the society. So I cannot file a lawsuit for you because you have only contract with him. Wrong. I can book you in tort. In tort, the lawsuit will be filed with unlimited liability. Whatever you have incurred, irrespective of your 100 real contract. Contract is different. This says. Now, there's a tricky case related to that. I'll give you the facts. Now you decide. That will be end of this tort part. There is this very famous case, by the way. Donut versus Stevenson. It's from your UK's legislation. There were a boy, a girl. They go to a restaurant. They ordered some drink. That drink bottle was not transparent. There was some label outside it. The girl started drinking. She was pregnant. Pregnant might be. So she started drinking. And when she was drinking, she finds that there is a snail inside it. Okay. Yeah, she get faint and she was rushed to the hospital and there was medical injuries. Now this gentleman, he filed a case against the restaurant. So restaurants say that it is not possible for a prudent restaurant manager that he can see across the bottle which has label over it. So as per these principles, I don't have any responsibility. You should contact the manufacturer. Now that gentleman, he files a case against manufacturer. Manufacturer goes and says privity of contract. You don't have any contract with me. You had the contract with that gentleman with whom, to whom restaurant you have gone.
Okay.
You cannot file a lawsuit against me. He's right in his purview because he don't have any agreement. He don't know the end customer. He don't have any direct agreement with him, right? So as per the definition of privity of contract, he cannot file a lawsuit against him. So this was the discrepancy in this case. Now tell me what would have been decided by the court. One by one.
No. Is there any back-to-back contract like that?
As I said, in the facts of the case, the argument from the manufacturer is I don't have any contract with this
They might have
gentleman.
a contract with the restaurant because they purchased the
Restaurant purchase from the market. And even if he has that contract with him, the restaurant can sue him. I gave the example, right? If at all he has a contract with him. This gentleman has no contract with him.
In this case, manufacturer to be sued.
Why? Under what ground? Privity of contract, he is not responsible.
This is the tortious liability.
Huh?
Tortious liability.
Okay.
It's a consumer problem.
Okay. So again,
So consumer needs.
the purpose of telling you is that is there privity of contract in tortious liability?
No, so because
No.
tortious liability is independent. of
Yes.
contract.
Because contract itself is not applicable in tortious liability. So the court decided consumer can bring an action in tort against the manufacturer even when there is no contract exists between manufacturer and customer. This was a landmark judgment.
It's implied, right?
Yeah.